Continue with our afternoon session of the Conference on Mass Violence and Human Rights, the Global Politics of Truth and Justice. I want to thank again our distinguished guests for joining us. They are each going to speak for 20 minutes, 15 minutes, and then that will provide us plenty of time for Q&A. So we have with us, you all have handy bios with information on each of the speakers, so I will not read that back at you. You should simply know that these folks are among the most prominent folks in their field, and that we are very, very honored to have them with us to shed light on these complex and vexing questions. We are going to, shall we speak in the order in which you are listed? Okay. So we'll have first Professor Richard Wilson from the University of Connecticut, followed by Professor Lisa LaPlante from New England School of Law, then our very own Jamie Rowan, then Vladimir Petrovic, and then our discussant will be Professor Charlie Carpenter from the Umass Political Science Department. And so please stay with us. As earlier announced, there will be free food, free food and free wine and beer for those of you who are old enough to drink, and other refreshments if you're not. So without further ado, I'll turn it over to Richard.
Thank you very much, Sonia. It's fair to say that Sonia Alvarez is the favorite speaker of the Institute for Latin American Studies at the University of Connecticut, so I've seen her, I think 3 times speaking there, and I'm very glad to come to her shop now. And also thank you to Jamie for organizing such a great event in your first year. You're very brave and courageous, so congratulations to you. I'm afraid I haven't got any visuals. The only visual today is me, and I apologize for that. But there is a paper, and if you'd like to read a more worked out version of my talk, then Jamie has a copy or I have a copy. You can just look me up on UConn School of Law. I'll be talking very briefly about what kind of histories do international criminal tribunals write. I wrote a book about this, so you can see the big picture. It's called Writing History in International Criminal Trials, and that came out a few years ago. But I'd just like to take a piece of, a different piece that I didn't talk about in the book, and talk about those trials today. And those I'll call propaganda trials. Trials that dealt with incitement to genocide, incitement to racial violence or ethnic violence. And I will be talking about trials from Nuremberg to the International Criminal Court. International criminal tribunals have one difficult historical question, and that is to explain the mass participation, the mass civilian participation in crimes against humanity. In the instances that I'll be talking about today, Germany in the 1930s and 40s, Rwanda, the Balkans in the 1990s, and the Kenyan election violence of 2007. In each one of these instances, there's mass participation, high levels of civilian mobilization and participation in crimes against humanity, and at least, if not participation, a high level of tolerance on the part of the population for crimes against humanity that are committed against minority groups. Tribunals puzzle over this. They try and understand it. And when judges write judgments, they often make an effort to explain this mass participation. And the answer in many of these tribunals is propaganda. That is, propaganda has become, in these instances, the dominant historical narrative for explaining popular mobilization. And there's been a growing emphasis on propaganda, persuasion through the state media as a causal factor in the violence. Now, it starts fairly gently at Nuremberg. There are 2 propaganda cases the case against, there are 22 members of the Nazi high command who are charged at Nuremberg. Two of them are propagandists. One, Julius Streicher, is the editor of Die Stürmer, which was a kind of Nazi propaganda rag, which was publishing in the early 30s and didn't publish actually during the war when Streicher was under house arrest. And he said really awful and cited in Der Stürmer, he said things like the Jews of the East, as the German military moved into Poland and Russia, he said the Jews of the East must be exterminated root and branch. So clearly incitement to genocide. The other defendant was Hans Fritz, who was second in command to Goebbels in the Ministry of Propaganda. The trials themselves didn't treat these suspects as really very important. The important actors were Göring and Hess and others, Kaltenbrunner. Those are the ones seen as really taking part in the conspiracy to wage a war of aggression and commit genocide against the Jewish population of Europe. Fritz is actually acquitted. He's one of the very few at Nuremberg who's acquitted. But Streicher is convicted, and it's very interesting to look at that judgment because it's one of the few judgments at Nuremberg when the judges actually talk about the broader context. The convictions of the other conspirators, they're pretty short and they stick to a very tight fact pattern. In Streicher, you get one of the few instances where the judges are saying, why did this all happen? And what they argue is that propagandists created the psychological basis necessary for the extermination of, the attempted extermination of the Jewish people, and also the support of the German population for waging an aggressive war. I'll quote from the pre-trial brief against Fritz, and it's the same wording against Streicher, that their actions, their propagandistic actions, I quote, created in the German people the requisite psychological and political conditions for aggressive war. Streicher is convicted of crimes against humanity and hung, but the cases against the two are of accomplice liability. This is a relatively low level of liability. The actions, the speech actions, were not direct causers of violence. It was more their act of encouraging, of creating a psychological mindset within the German population. So not strong causation and not a strong, directly impactful kind of role for propagandists. They're really, one is acquitted, but the one who is convicted of really being an accomplice. The language changes when you come to the Rwanda Tribunal in the 1990s. And in Akiyesu, he's a mayor who's convicted of incitement to commit genocide. The judges refer to a causal link between his speech acts and the subsequent genocidal acts against Tutsis. Nahimana, which is the media trial of the owners of Radio Télévision de Mille Collines, in that judgment, there are 3 defendants, and the judgment refers 16 times to the causal nature of the broadcasts and how these broadcasts incited Hutus to commit genocide against the minority Tutsi population. So unlike Nuremberg, the owners of the radio station are not accomplices. They're convicted of directly committing genocide by virtue of their broadcasts, even if they didn't play any other role, and they didn't. They weren't at the barricades. They weren't directly participating in any material acts of genocide. The language gets strong as well and stronger at the Yugoslav tribunal in the Šešelj trial, where 3 of his speeches at Zvornik, Vukovar, and Hrtkovci are seen as, in the eyes of the prosecution, causing the subsequent acts of forced displacement, murder, torture, and sexual violence that occurred in those locales after the speech. Causation is the ultimate issue in the Sheshel trial. It's still ongoing, and we don't have a verdict yet, and we hope to have a verdict sometime this year, but it's been a trial beset by all kinds of problems, including the removal of judges for bias, Sheshel himself, who has turned the court into a circus, and so on. The most recent case that I'd like to refer to is that of the sitting vice president of Kenya, William Ruto, and a broadcaster who supported his campaign called Joshua Sang. And they're indicted for crimes against humanity. Their case is ongoing. It's happening right now in The Hague. You can follow it all online if you wish. And they're indicted for co-perpetrating crimes against humanity. And Joshua Sang, who's the radio DJ, is seen by virtue of his broadcasts as co-perpetrating, along with William Ruto, during the campaign in 2007 in the last Kenyan elections, of the murder of approximately 2,000 supporters of the opposition party who happened to be an opposing ethnic group. And here, the causation again is even stronger. Sang, if he is convicted, will be convicted of co-perpetrating by virtue of making an essential contribution to the commission of the acts. Essential contribution means, in legal terms, but for causation. But for his speech acts on the radio, the events wouldn't have happened. That's a very high bar of causation. It's not like accomplice liability, where you can have many other factors at play. With essential contribution and co-perpetration, you really require the highest level of causation beyond a reasonable doubt. So in the course of this 60 years that I've described, we've seen international criminal tribunals, one, using propaganda to explain mass mobilization of the civilian population in participating in crimes against humanity, and secondly, asserting an ever more causal role to speech acts on the part of political leaders, broadcasters, and so on. That's the overall pattern of international law. But, and since I'm an academic, I say but, there are two problems here. One problem is that the social science is not quite bearing out this very strong causal connection between propaganda and violence that the courts have identified. I'll just mention three. There are three fascinating studies of the Rwandan genocide. One by a political scientist, Scott Strauss, who's now at Wisconsin, who wrote a fascinating book looking at the level of violence in Rwanda, and he finds that it actually didn't correlate to the radio broadcasts. The violence and the broadcasts were independent. The broadcasts only reached 10% of the country, Kigali and then a town in the north. The violence was occurring in rural areas where there were no broadcasts, and they were happening actually sooner. So he does a very complex quantitative analysis, and he finds very little correlation between broadcasts and violence. He also does 100 perpetrator interviews in Kigali prison with convicted perpetrators. And he finds that they put propaganda way down on the list of motivations for their involvement in the genocide of Tutsis. They admit to it, and they say, it was local political leaders, and it was male kin coming to my house saying, come on, we need to go out to the barricades now. Now, one has to take this with a pinch of salt, because one of the key aspects of propaganda is that it works in unconscious ways. People aren't always aware of the ways in which they're being persuaded. So it tells us something, only tells us so much. We don't want to overwork that, but it's supported by Charles Moronka, who's a Rwandan anthropologist, who again does a lot of work with perpetrators after the genocide. Charles is a Tutsi, and he's a very brave guy. I worked with him in South Africa. He goes right back into Rwanda after the genocide as a Tutsi, as the minority target group, and starts doing interviews with perpetrators. And again, he finds that the radio was not one of the main motivators for their involvement in participating in the slaughter. But then there's a study by a Harvard economist, David Yanagisawa, which is, again, a highly quantitative econometric analysis of prosecutions after the genocide correlating with radio broadcasts, and he finds a correlation between the radio and the violence. And he says the radio caused about 10% of the genocide, which approximates to about 50,000 deaths. So the social science is mixed. The more qualitative work is not showing a correlation. The political sciences is critical. The economics model. So these are all different models of getting at the same problem. They're coming up with different kinds of results. That's problem one. Problem two is the weakness of the eyewitness testimony in these trials that would point to propaganda as one of the main factors. And I have to speed up here. As you'll probably know, at Nuremberg, there was very little in the way of witness testimony. The prosecutorial strategy was documents. Documents, documents, documents. They only had one member of the camps testify. They had very few of the insiders testify. They used the Nazis' own documents against the Nazi high command. And so there was I've done some historical work on this, and Connecticut Senator Thomas Dodd, who was executive counsel at Nuremberg, said, we've got a stormtrooper here who will say that Streicher's Die Stürmer is the reason why he joined up and joined the stormtroopers. He read about a story about Jews ritually sacrificing children, and that's why he joined, and that's why he committed atrocities. And the State Department, who was advising the prosecutor, said, for God's sake, don't use him. We don't want any witnesses, any insiders. We just want to use the documents, because as soon as you get into subjectivity and what influences there are mobilizing people, it's a can of worms. Stay away from it. So Nuremberg actually put aside one of the few pieces of evidence they had to show that insiders were influenced by propaganda. You look at the other trials I've mentioned, Nahimana, they have not got one perpetrator saying I was motivated by the radio to commit genocide. I'm not the only to observe this. They don't get actually one perpetrator. And this is true of all of the Rwanda trials, and there were 161 indictments. At the Sheshel trial, they find 6 insiders who are willing to say that they were followers of Sheshel, and his words incited them to commit acts of atrocity against their Croat and Muslim neighbors. But they all fall out during the trial, or recant on the stand and turn defense witness against the prosecution, which is not what you want when you're a prosecutor. In the Ruto Sang case last year, 9 witnesses fell out of that trial, and they basically had to abandon the trial. So in both Sheshel and the Ruto Sang case, and in the prosecution case in Nahimana, all of those cases, so 3 different tribunals, 3 different cases, the insider witnesses disappear or they haven't got them. And this is a feature of propaganda trials. The only way to prove it is to rely on inside material perpetrators, and for one reason or another, they are recanting and dropping out of the trials. And that's partly a comment on the coercive capacity of international criminal tribunals. We think of international law as being very powerful and this kind of Rolls-Royce legal service, but in fact, the tribunals are very dependent on states, and they don't have the coercive capacity of states to protect insiders, to protect the material witnesses who can turn against these powerful political leaders. I have to wrap up. International criminal tribunals have spoken with great certitude about the history of the conflicts they're adjudicating. They've identified broadcast propaganda, state propaganda, party political propaganda, and given it ever more causal power as an explanation for why mass mobilization, mass participation in crimes against humanities occurs. But there's a very weak basis to this on evidentiary grounds. And I think what's going on here is that in propaganda trials, judges are turning what's called to, in the parlance, their moral expressivist function. That is, they're engaging in moral denunciation, they're engaging in expressivist kind of language. These trials are very new. The institutions are quite weak and fragile. And so the judges turn to propaganda as an overarching moral narrative on which to hang some expressivist kind of language of denunciation. And I'll just finish with my recommendation, because even though I'm an anthropologist, I work at a law school, and lawyers want to know what the point is. And the point I would say is this: we need to go back to the Nuremberg model. Speech very seldom directly causes criminal offenses. Instead, it works along with a number of other factors that are themselves jointly sufficient to cause a set of crimes. So let's go back to the Nuremberg model of accomplice liability. An accomplice liability accepts multiple causation and a number of intervening factors. That's how speech operates and persuasion operates in orchestrated state violence. So away from the directly causal essential contribution, and instead understanding how speech and propaganda and broadcasting shapes the conditions of what is acceptable and what is sayable. Thank you.
Good afternoon, everyone. I was telling my co-panelists that I attended Umass when I was 3. My mother got her Bachelor of Science here, and I went to classes. I did get a Master's of Education here, though, so I am an alum. That's not on my bio, so it's exciting to be back. And my favorite place was the cafe. I liked the Jell-O when I was 3, so it looks very different today, though. So, like Richard, I have a lot of interest in the role of media, except for I've looked at it during transitional justice and after transitional justice. And I should say thank you first for the invitation to be here. It's always very exciting to have co-panelists who really care about what I care about, and we get to talk about it. So I've very much been looking forward to this and braved the pipe this morning to get here. I'm talking today about a paper that I wrote specifically looking at the way that national trials generate a conversation, a debate, and my source was looking at local news accounts as well as opinion pieces. And in doing this, I'm looking at how collective memory forms and then conscience, collective conscience. And I challenge a dominant idea in the theoretical writing in transitional justice that one collective memory results from this process. And I contend instead that there's often multiple collective memories about what happened, and some of them even justify the violence. And I question whether this multiplicity of memory challenges the overarching aims of transitional justice, such as building a culture of rights, reconciliation, the rule of law. And in doing this, I'm looking specifically at the trial of former Guatemalan dictator Efrain Rios Montt in Guatemala that occurred in 2013. I had the opportunity to be a trial observer actually when I was at the Dodd Center at UConn, went down with a group of students, and also my desktop archival research. I'm going to contextualize my talk a little bit about what is the study of memory. In transitional justice, the idea of memory has attracted a lot of attention because, well, it's about truth. People tell their stories, they go to truth commissions, public testimonies. This becomes a part of an official report that is often supposed to correct long-standing denial of what happened. It's supposed to supplant that denial and set the record straight. So in early scholarship in this field, there was a lot of theoretical assumptions that this process led the whole society to get to the same conclusion about history, which is human rights violations occurred and they were wrong and even unlawful, and that they shouldn't happen again and that they were never justified. But with more empirical research, scholars began to challenge this assumption and show that actually there's many more nuances to collective memory. And in fact, they're highly contested in these situations. I'm not going to get it for sake of time. I'm not going to mention all the people that talk about this, but it's important to acknowledge there's some great literature on this. So in this contestation, there are what I call memory makers, and to put them really simply into two groups, there's a group that wants to deny what happened. Those are usually the perpetrators and their supporters, and those who want us to look at what happened, and those are the victim survivors and their supporters. And this is a process that is a part of the post-conflict, post-repression situation that doesn't end once transitional justice starts. Truth commissions, trials, the different mechanisms that are part of transitional justice, they actually increase, especially because the stakes are usually higher if there's criminal justice in particular. But it can, these mechanisms can change the terms of the debate, and that was something that I saw in my own observations that I'll share in a second. But in terms of looking at this dynamic, it occurred to me that once the physical violence ends, a memory battle begins. It's a different kind of feuding, and it often takes place in the media. It's the media that publicizes these different opinions and these, whether they're factual reports or the radio or the TV. And it's not always clear who's going to win this battle. And so this creates a paradox in transitional justice. We've heard a lot about paradoxes today, in which the aim of building democracy, freedom of expression, of opinion, is one of the aims of transitional justice, so we should like this. But we also aim for a culture of rights, rule of law, where we agree that there are certain things that you should not do, serious human rights violations. And I'm interested in how this paradox plays out, especially with relation to national trials. So Richard talked about international trials. National criminal trials are somewhat new because Nuremberg International, long time, Argentina set up its first truth commission, and basically because of a sort of amnesty could not continue with criminal trials. And so a lot of the scholarship talks about truth commissions being the alternative to trials, and then suddenly they became their own important thing. And then a very important decision from the Inter-American Court of Human Rights in 2001, because of the Peruvian situation, said you can't have amnesties. So suddenly you see more national human rights trials, such as Alberto Fujimori in Peru, Jorge Videla in Argentina, and Efrain Rios Montt in Guatemala, among others. And so suddenly we have the opportunity to look at how memory battles occur in national settings where the trials are taking place there. One scholar, Mark Osiel, is one of the people who claims that trials create civil discourse and dissensus, but that this can lead to a moral condemnation of the path and even be cathartic, in that the courtroom is somewhat of a neutral arbiter of the past and can bring resolution and even reconciliation. I call into question this claim based on what I've observed and studied. One collective memory doesn't seem to ever dominate, but it can change over time. So I'm going to talk about the trial now to get to the evidence that I have for my conclusion. Really quick summary for sake of time. In Guatemala, it was a 36-year dirty war between the government and the guerrilla, which were trying to bring social justice to the largely indigenous communities. There was a coup of then socialist president Jacobo Arbenz, a lot of brutal military dictatorships, and one in particular by General Efrain Rios Montt occurred during 1982. For just 17 months, he managed to do a lot of damage through his scorched earth strategy, where he basically conflated indigenous communities with the guerrilla opponents. And for many decades, he had quite a lot of protection. He even became a senator. He had immunity. The Truth Commission in that country was set up in 2004, and while it did set the stage for individual criminal liability eventually, it didn't address the individual criminal liability specifically within the terms of its mandate. So what you see are many steps along the way to try to bring the general to justice, and there's a great documentary, Granito, How to Nail a Dictator, which documents all the different steps, even going to Spain to try to bring him there for justice. Finally is brought to justice when he loses his immunity and a very bold attorney general decides to press charges. So in this special court, the trial began with an 86-year-old Rios Montt in March 2013. He was charged with genocide and crimes against humanity. So he was one of the only former heads of state to ever be tried in a domestic court for genocide. Very historical. These were based on allegations of 15 massacres as well as some other crimes, including sexual violence. The trial was quite spectacular. They had about 100 victims. It was the quickest trial you've ever seen. One of the strategies of the defense was just to use a mechanism called amparo, which ironically is a due process protection of your defendant. So they would orchestrate problems and then stop the trial. It kept going and stopping. But eventually the Judge Barrios, concluded on May 10th with a conviction for genocide and sentenced him to 80 years. But even before the ink could dry on the 700-page decision, the Constitutional Court decided to annul that based on these amparos. And to this day, the trial was supposed to start this year in January 2016, and it was stalled once again. So one of the things that I was interested in when I was there was reading the papers and the way that the trial was being talked about. And in particular, it became clear there was a very stark debate. Si hubo genocidio, no hubo genocidio. There was genocide, there was not genocide. And this was debated in the press. And one of the fascinating things that was the conversation occurring between the different sides. Those who said there were genocide pointed to the evidence that was brought out into the trial. When you have so many victims testify to the exact same occurrences, the defense said they were coached, others realized, well, this was a systematic policy, and also some military documents like Plan Victoria 1982, Plan Sofia, that was brought into evidence, and they said, how can you not see that this was genocide? The majority of the fatalities were the Mayan population. What's important is that the Truth Commission did not create this kind of debate. From my interviews, it seemed that there wasn't as much publicity, media coverage, there were no public hearings, and that this kind of open debate did not occur. I see that as a positive. But on the other hand, those who denied genocide had a very strong voice in this debate, and even some worrisome propaganda tendencies where they would pay for this rant in papers where they called everybody terrorists, including the foreigners who were observing the trial, and all their condemnation of what was occurring. Despite that, there was a portion of the commentary that was very legal and did look at the law and the question of intent and whether Mayans can kill Mayans, right? Because a lot of the soldiers were actually Mayans, and whether the intent could be satisfied. But what they did admit to was that there was atrocity, that there were crimes against humanity. As I mentioned, he was tried for genocide and crimes against humanity. So what's fascinating is that while there was denial completely of any atrocity up until this trial, suddenly they had to concede, well, there were problems and there should be criminal accountability, but it's not genocide. That's impressive, except for by not talking about genocide, one of the things that concerned me was that the same underlying problems that led to the genocide continue today in Guatemala in terms of inequities, discrimination, the problems of the Mayan community. So in not coming to terms with that past, whether in the conviction being overturned, but the country's still struggling with that reality. And there was the resistance to even admit to it had to do with such a profound identity as a society, and a lot of that came out in the editorials in the papers as well. So where does this lead me? My interest is when we're looking at transitional justice, we are interested in preventing new occurrences, redressing the past. And in taking on these mechanisms, we open up the possibility that there is not that resolution. And for victims in particular, there's not that resolution, especially if there's democratic space to hear that it never happened or it wasn't what it was. And are we okay with this? One of the important distinctions between collective memory, and maybe we're okay with multiple collective memories coexisting, but at a certain point, and this is Emile Durkheim talks about a conscience, a collective conscience about what is right or wrong. That can be translated into our contemporary framework of human rights, which is now legally binding. For the most part, we haven't incorporated it into our national law, but there are some obligations which are international customary law, and in these countries there is more adherence because of the inter-American system. But if we want this moral consensus to form, the question is, what is the role of media in these contexts? And how far do we want to go in mediating this, the different memory makers who are part of this debate? Do we want to control the conversation? Do we want to leave it open to chance and hope that they get there eventually? Often it's the same media that was a part of the original conflict, right? Even if it wasn't a direct causation, it created some of the ambience. Although I am also in the law school, I'm hesitant to make conclusions. But one of the conclusions that I arrived at was we don't talk about the role of media as much as we should when we're talking about transitional justice. I'm not even a journalist, and I find that I'm often called upon to talk about this because I've studied it a little bit. But in forming transitional policy, I think we do have to self-consciously ask ourselves, what is the role of journalists? What is the role of the media? How are they a part of this political and legal project of actually creating a new society that respects everybody and protects everyone? So, thank you.
I'm just going to set up the projector. Thank you, everyone, for being here, especially my fellow panelists and our discussants. It's really wonderful to see this come to fruition. I am here to talk about the research that I have been doing in Colombia, which is undergoing a process right now, and the lessons that we've heard, especially in the most recent presentation, as well as from our original speaker, you'll see the themes playing out. The title of my talk is Justice is a Dead Mule in the Road, a Truth Commission in Colombia. What am I supposed to press? Uh-oh. Does someone need to press the keys? Okay, thank you.
Just point at me.
Deal. All right, so my teammate. So the title of my talk comes from a news article that came out over the summer in June. The theme of justice is a dead mule in the road to peace, is actually the full quote. And this is a quote that the lead FARC negotiator, the Fuerzas Armadas Revolucionarias de Colombia, okay, the Armed Revolutionary Forces of Colombia, which were engaged in peace negotiations. In June, the negotiator said justice is a dead mule in the road to peace. And by September, there was an agreement on the issue of victims' rights. And the idea of victims' rights at the time was around whether or not this group, this guerrilla group, the oldest guerrilla group in the hemisphere, and the oldest conflict in the hemisphere, would go to jail. Right? That was what they were saying by justice. You make us go to jail, there will be no peace. So they came to a deal. How did that happen? In my work, I look at the idea of transitional justice and the promotion of truth commissions as tools, right? So I'm not studying transitional justice as a field. I'm not looking at truth commissions as transitional justice mechanisms per se. I'm looking at how this idea gets utilized by different actors. And I argue that what happened between the lead FARC negotiator saying justice is a dead mule on the road to peace and making the agreement has to do with the way that transitional justice has come to be understood in Colombia, and not only that, how it has been instrumentalized by different actors. Now, Colombia has a 60-year conflict. This is a very, very complicated story. And what you'll hear from my argument is that in the ways in which transitional justice has been instrumentalized, and truth commissions in particular have been promoted, is problematic. And part of the problem is that the history of this conflict involves a variety of actors, including a variety of guerrilla groups the paramilitary groups that were funded in part by the government as well as wealthy landowners to protect themselves, as well as the state, right? Military actors that also committed atrocities to kill, involved in killing these different actors, particularly the guerrilla. And the conflict is not just between these different groups, right? They're not homogenous groups. This is a map that shows you the level of conflict. People don't realize that Colombia is treated like a state, but really the sovereignty of the state has been contested and different groups have been in charge of different regions. So here you see that in the yellow, at the height of the FARC's power, they controlled that much land. And in the orange, the paramilitaries, right, controlled that much land. And then you have the ELN, which is another guerrilla group, and then other armed actors, right? And they control large swaths of territory. This is also racially divided, okay? So on the coasts, in particular over on the Pacific coast, you have a largely disenfranchised black community that has been the victims of violence. They get overlooked in the story about guerrilla versus paramilitary versus the state, right? As well as other groups. And so the history of this conflict, coupled with the infusion of drugs and drug money, and illegal armed actors that are just operating with drugs, narco-traffickers that don't fall within these various categories, right? And so the level of violence in this country, which has the largest internally displaced population in the world, right? It's now with Syria and Sudan, and second, it gets, how many people are we talking about? We're talking in the tens of millions of people who have been displaced from their homes. So we're talking about huge levels of violence and problems that we're trying to address right now with truth commissions, with transitional justice interventions, as they're called. Now, the story of transitional justice entering, right, this conflict as a solution begins with Álvaro Uribe, who came to power in 2002. This man was the mayor of Medellin, which is an area that was undergoing a lot of violence. It was the home of Pablo Escobar. People often mention Narcos to me when I talk about Colombia these days. If you've seen that show, right, we're talking about his territory. And Álvaro Uribe's father was killed by the FARC. And this man does not like the guerrilla, and he created a program to fund paramilitaries to fight back the guerrilla when they were there was an incursion on Medellin. They were ultimately illegalized, right? So he basically created the paramilitaries that he later illegalized. And when he came to power on a platform of making peace with the paramilitary groups and killing off the guerrilla. And that was his entire platform. Now, how is he going to make peace with the paramilitary groups? This is where we see him getting interested in the idea of transitional justice. When he first came to power, he proposed restorative justice for the paramilitaries. He was basically going to say, demobilize, put down your arms, and we're going to give you services to reintegrate you into society. And the international community that was observing this, as well as the domestic, incredibly active human rights community, condemned that and basically made it impossible. And Uribe went back to the drawing board with consultants from the International Center for Transitional Justice and elsewhere, and came up with a new plan. The plan was codified in what is known as the Justice and Peace Law of 2005. And here you see stones that basically say we're going to have truth, verdad, justicia, which usually refers to criminal accountability, reparación, reparation usually meaning economic, and memoria, which is the word that we use for historical memory, right? But really this truth, justice, and reparation piece is what this was all about. And what they did was they created an alternative judicial process whereby paramilitary actors who agreed to put down their arms would receive up to 8 years in jail in exchange for telling the full truth of what they committed. Now, this law was challenged in the courts, and the Inter-American Court, as well as the domestic constitutional court, found the law unconstitutional and basically said you need to have further guarantees that the full truth will be told. So you see truth playing a very big role in how the leadership in Colombia was understanding the resolution of this conflict, right? And you had this National Commission on Reparation and Reconciliation, which my co-panelist Lisa LaPlante and her co-author Kimberly Thieden called a sort of truth commission. Right? It was something in which individuals would go tell their stories based on what they had experienced. They would receive financial reparation. They called it administrative reparation. Right? And so this was considered the first transitional justice law in Colombia. It was heavily criticized from within by victims' rights groups that said this is not adequate payment to us. This is also not adequate punishment for them. But this became a sort of foundation for the next steps. Now, at the time, in 2010, when I first went down to Colombia to do research, what I saw was a lot of concern about truth commissions, right? You have the National Commission on Reparation and Reconciliation. There's already critiques that this was really about amnesty. This was about impunity. This was about Alvaro Uribe trying to make sure the paramilitaries don't get punished. So advocacy groups were skeptical, right? And they were skeptical of this idea. They said this fad, this is an example from the victims, director of a victims group. This fad came to be because of the CNRR, that National Commission on Reparation and Reconciliation. Because we were copying in what happened in other countries. And I ask those promoting transitional justice, beside theories, what do you know? Right? So the majority of the victims groups that I spoke with in 2010 were not big fans of this idea, nor the individuals from the West and the North who were coming to tell them how to solve their problems. There was also concern that at the time, the FARC, right, the guerrilla, was still in conflict. There is, and there will be, but there was still violence, right? And so you see in this quote a concern that actually a truth commission is not something that is useful in a country where the violence is still ongoing, right? So you can read this quote. We're scared. We're scared of actually engaging in a process right now because all of these power holders would go to jail, and that might further destabilize the country. So we really should be careful when talking about these interventions. At the same time, what I find is that truth commissions are an ideal of a future when the violence stops. And so this is a very prominent victims group. It's victims of the state. So these are people who largely their story is their family members were guerrilla who became a political party that was then killed in what the Inter-American Court has called a genocide. And they said, look, we consider it as important that even if today there are no conditions, we should still build a proposal around a truth commission. So that's 2010. Okay, now things start to change. Because you end up having, courts, it's okay. You end up having courts start to decide, okay, we need to make sure that we protect victims, right? And you have both the Constitutional Court in Colombia, you have the Inter-American Court, and you have the International Criminal Court looking down and saying to the government, you cannot amnesty anyone, okay? That's now illegal. And you need to make sure that victims get their rights to truth, justice, and reparation. And why? Because the victims groups in Colombia get more political power, right? Over the course of this, they've gained more and more prominence. Victims are now recognized in Colombia. You also see the FARC, okay, Uribe's strategy slightly working. The FARC are now beaten down, right? And they decide we're going to come to the negotiating table. And when they come to the negotiating table, they now have a request. They don't want to be punished. And so the idea of transitional justice gets very useful here, right? In 2005, we had the Justice and Peace Law, considered the first transitional justice law, but it's not actually in the law. 2011, you see a victims law, which talks about victims' benefits, and the policymakers who create this law call it a transitional justice law. And it sounds good. We're going to provide reparation for victims, and particularly for victims of the state, because the previous law didn't even recognize victims of the state. It was only guerrilla and paramilitary. So the victims law seems good, but the word transitional justice, according to the policymakers that I spoke to about this law, they used that idea to say that it was temporary. The only way they could get this law passed was to convince other policymakers that they were only going to give reparations for 10 years. This was going to be temporary. And if we know anything about this violence and its aftermath, it's not temporary. In 2012, as the government is sitting down to make peace with the FARC, they decide to create this law, the legal framework for peace, because they don't want their peace process hindered by legal restrictions on amnesties, right? They want to have the opportunity to say to the FARC, put down your arms and you won't go to jail, because they know they need to do that. So they created a constitutional amendment, and in the constitutional amendment, that's what is the legal framework for peace, they call them transitional justice instruments. They use the idea of transitional justice to justify, right, what they think they're going to have to do to make peace, which is basically to make sure that the FARC don't think they're going to have to go to jail. In addition, they put in the legal framework for peace that there will be a truth commission. Why? According to the policymaker, we didn't want to commit to the idea that there was going to be a truth commission because we said not necessarily you create a truth commission by a constitutional amendment. It has been in decrees, agreements, all sorts of things. You don't have to put that in the Constitution. But since the beginning, we were in need, this is direct quote, to have other mechanisms that are not the judicial one, right? And so this policymaker who is designing the legal framework for peace is saying, we put a truth commission in that because we needed to show that there was an option, right? So the Truth Commission, again, gets instrumentalized by the government as they try to make peace. Next. So in 2012 to 2015, we have peace negotiations going on. And agrarian reform is on the agenda, right, between the government and the FARC. Drugs are on the agenda, how we're going to deal with drug trafficking. Demobilization, how are we going to put down arms. And the one that becomes most tricky is victims' rights, right? This question of justice. And this becomes a battle. It becomes a battle between Santos, the character on the left here, who's the new president, and Uribe. No longer president, but a senator and a leader of the right who does not want to make peace with the FARC and continues to say that this is an impunity process, this entire process, and it becomes framed as a battle over transitional justice. In the media, it's a battle over, is transitional justice going to allow us to punish these people adequately, or is it going to be used to free them? And in my research in May, what was happening was advocacy groups were trying to educate people on what transitional justice means because victims were worried. They don't want impunity. And so there's this battle over creating the meaning of transitional justice in Colombia by these different groups who have very different goals in mind. In the end, we do get a peace deal, well, we don't have a peace deal yet, but we have an agreement over victims' rights. And what ended up happening is this question of justice is now decided by an effective restriction of liberty. No one knows what that means, but the FARC are going to have an effective restriction of liberty, right? This creates some questions, right? In the debate in constitutional reforms, right, the question of political participation continues to be really important. Should the FARC be able to participate in the government, right? 3/4 of city people don't approve of political participation, and most of the polls that you see are of city people or of elites, right? Politicians want in on this deal. They also want an effective restriction of liberty for their violence. Paramilitary groups also want an effective restriction of liberty for their violence, right? So this is a new way to make sure all the different armed actors get impunity. And what you see in this really interesting way is the right and the left, extreme right, really on the same page. Who called this a piñata of impunity? The head of Human Rights Watch for Latin America called this a piñata of impunity. Who called this a substitute for justice? Uribe, right? And so this is a compromise that is causing a lot more division. You also have the inevitability of a truth commission at this point, all right? So a truth commission is in the constitutional amendment. There is very likely going to be a truth commission. This is the head of the Historical Memory Center explaining to me that everybody wants a truth commission, right? This is just assumed now there's going to be a truth commission. Here's the problem. I'll want one. I'll want different things, right? The truth commission is going to tell my story, right? Whether I'm a military or I'm a survivor of something, whether it's, whatever my dad, they all wanted to do completely different things, and that's what my data points to. They wanted to clarify the most responsible. Why? Because they want future prosecutions, right? So there's this real tense relationship, whether is this going to be an alternative to criminal justice, or is it going to be a foundation for future criminal justice? And that's an ongoing question that's going to have to be figured out, right? People think it's going to enable victims to heal. And we think it's going to clarify the causes and consequences of the violence. As we have seen from today's presentations, this is impossible. It's just impossible. And putting all the hopes into a truth commission is going to lead to a lot of disappointment. The future, basically the future in Colombia, the violence is not going to end when the FARC and the government come to peace negotiation. If you look at the new maps, all of the blue are what we call Bagfrin, okay? You have illegal armed actors taking up large swaths of land now. The violence is continuing, the drug trafficking is continuing, and now as the peace process moves forward, there's this sign in Bogota I always like to quote where it says, peace at the sacrifice of justice. Basically, we're pursuing these peace processes, but all the while Santos is selling out the country to mineral companies, to foreign actors, and the foundations of violence are not really being addressed. And so we're focusing all this attention that there's going to be peace through this peace process, the Truth Commission, maybe a criminal justice process, but the underlying factors, no change. Thank you. Very sure. The cheery part is that the activists are incredible. And they're fighting us. All right. That's
good. Let's see if I'll have more luck. I'd be much obliged now that we have had practice. Thank you so much. Thank you kindly for the invitation. It has been a really eventful day, and I'm going to do my best to build on what my predecessors have been already speaking, the more so because I understood that I'm one of the only persons between you and the promised heaps of food. So I wouldn't risk you getting angry and eating me alive. I will try to build on some of the tensions which have been underlined today, because the entire field of transitional justice is completely beset by tensions. Just enumerate what we've heard today. Peace versus justice, reconciliation versus stability, trials versus commissions, and so on and so forth. So sadly, I have to add to this confusion and put in front of you yet another tension which exists in this field. Implicitly, it was also mentioned today, and this is the tension between international and national level in, let's say, approaching transitional justice mechanisms or implementing them for that matter. So basically I'm going to take you to a trip around the world, because most of the examples used today have been from South America. I propose we go together to Southern Europe and try to see how this national and international tension played out in the field of Southeast Europe, more specifically in the former Yugoslavia. The reasons for this field are obvious. I have been a Yugoslav citizen until that country wiggled away from me, so I'm not anymore, not by my own volition. Yugoslavia is a country in Southeast Europe, the part of Europe which is also known as the Balkans, and it gained certain notoriety over the 20th century, mostly in the 1990s. It stands for utter confusion, it stands for lack of political culture, it stands for perpetual warfare, it stands for a mix of ethnicities which are unable to find adequate political articulation, which is pretty much what this map more or less depicts. I would of course contend that most of these propositions are simply stereotypes, but as we know, many of the stereotypes also happen to be true at the same time. Therefore, we are going to try to go and approach these things one by one. In the center of the Balkans, and the part of it which is most ethnically mixed, is the country which is now known as the former Yugoslavia. That country fell apart in the 1990s in a rather violent succession of wars in Slovenia, then in Croatia, then in Bosnia, then in Kosovo. And as you can see, this was the ethnic setup of Yugoslavia in 1991 when the country started collapsing. So you could see that there is quite a mixture on this map. And basically the other map shows that this country now split into 7 successor country states, all of them having much less complex ethnical structure. The cost of this leveling down of ethnic landscape was enormous. The wars altogether yielded 130,000 casualties, more than half of them civilians, and quite a number of refugees and internally displaced persons. Actually, this entire practice of flattening the demographic scene came to be known as ethnic cleansing, quite an ugly coinage which entered straight from Serbo-Croatian into all the global languages in the beginning of the 90s. You could also claim that Yugoslav case is interesting because Yugo wars belong alongside the Gulf War and all the rest of the wars to what Mary Kaldor tends to call new wars. Wars which had been accompanied with such an ardent media support that basically you could see some of the happenings real time as they were happening even before that they were happening. So basically you could not only hear about this ethnic cleansing, you could see it with your very own eyes. Vukovar, which is a city that Richard mentioned in his speech a bit earlier, is a city which was a cheerful place of about 35,000 persons, half of them Serbs, half of them Croats, many of them mixed people living pretty much alongside each other until 1991. And this is the same city, Vukovar, at the end of 1991, aerial shot of a city being bombarded, basically with almost every house being either destroyed or damaged. Next, please. What we could see afterwards was the paramilitary entering in already destroyed city in order to mop it up. This is actually the face of ethnic cleansing, which means random or not so random killing of people, moving them here, incarcerating them there, looting and taking away the property, and so on and so forth. And next one, please. Eventually, people are rounded up and then move elsewhere. This is exactly the face of ethnic cleansing. Please again. Having in mind that the media support to the wars was so ardent, so was the international reaction, or actually it seemed like that in the first place. Yugoslavia made it to the headlines in 1991, but in 1992, really big in August, when there was a huge set of features. Here you can see it in Time magazine, but basically it was everywhere else, about the existence of concentration camps for the first time in Europe after the Second World War, as the story goes, and so on and so forth. And the pressure for politicians to do something was immense, not the least because of this dramatic juxtaposition. On the one hand, Europe was uniting, but on its periphery, complete chaos. On the other hand, transitional justice discourse is just taking hold, the very concept taking hold. Sort of an era of optimism, and then in places like Yugoslavia and Rwanda, you get such a huge factual dementi that this is actually coming about. Now, how to approach this problem? Here you have the opening of a satirical comic book called Private Eye from London. This is a conversation between back then PM of Britain John Major and George Bush Sr. Upon seeing these news, Major says to Bush, "Is it time to act?" And Bush says to Major, "Yeah, act concerned." I think, in a sense, it captures well this context from which International Criminal Tribunal for the former Yugoslavia was eventually born. Again, Richard said a couple of words about the ICTY, and I particularly appreciate that he emphasized one of the common misconceptions that people have about international tribunals, that they are strong, potent institutions which are completely able to bring to justice whomever they want for whatever they want, and so on and so forth. I don't know how come that this commonplace is alive, having in mind that in the last 70 years we have had quite some number of examples to prove otherwise. International Criminal Tribunal for the former Yugoslavia was created in 1993 exactly as a sort of a response towards this enormous media attention to the crimes in the former Yugoslavia and undivided idea that this shouldn't be allowed to happen. Since making a tribunal is much less costly than bombing a country or militarily intervening or doing anything, actually. This is by far the cheapest way to deal with the crisis. This is how the crisis was dealt with in 1993. The war was still on, so nobody was really certain what is the future of this tribunal. And exactly like in the case of